If I could have your attention, sorry to interrupt the discussions because the interaction and meeting and talking with other people is great, but we're ready to shift to our next program segment, and I'm going to introduce Justin Brown, who's the research administrator for SPBR and SERB. And also, if there's anything, right there's Justin, and if there's anything about today's program that you think we ought to improve, do differently, Justin's the one to complain to. If you love it dearly, just tell me. But any complaints go to Justin. He's in charge of that. So Justin's going to introduce our next program, which is a little different segment, and hopefully everybody's all coffeeed up or had something to nibble on, and we'll have lunch in right about an hour. Thank you.
And I'm going to
Thank you, Chairman Casey. Thank you, Justin Brown.
You're welcome.
Good morning. This is case number 2020-REM-02-999, Winston-Salem versus Bureau of Underage Tobacco Surveillance. I am the Administrative Law Judge, Raymond M. Geis, playing myself. Today is August 24th, 2022. Today's hearing is being digitally recorded. Counsel, could you please enter your appearances for the record?
Attorney Anita Pax for the State of Ohio Bureau of Underage Tobacco Surveillance, also known as BUTS.
Hello, I'm Winston-Salem. I'm representing myself.
Thank you. Counsel, please proceed with your opening statement.
Thank you, ALJ Geis. Tobacco usage by minors is a huge problem in Ohio that carries many substantial health risks. We understand the addictive nature of nicotine, the active ingredient in tobacco. My client even hires those addicted to nicotine who have chosen to quit. But today's case involves an employee who will not stop using tobacco at work. Mr. Salem has been disciplined twice before not conforming to the Bureau's prohibition on tobacco usage. The Bureau simply cannot continue to employ a person who engages in behavior that is against the mission of our agency. What's more, Mr. Salem hasn't even been able to ensure that his work is done on time. The evidence will show that Mr. Salem neglected to ensure that the teenage tobacco usage report was completed. This is what Mr. Salem's job is all about. We therefore respectfully request that this board affirm his removal. Thank you.
Hello, Judge. I'm an insufferable addict of nicotine. I've tried to quit dozens of times. Without tobacco, I fall asleep at work. I cannot take extra breaks to smoke or spit. I admit I've been disciplined for tobacco use before. However, the last time, it wasn't me. It was the building maintenance superintendent who smoked and set the fire alarm off. The restrooms are not part of BUTS. They are shared by all the tenants and the public. Even if I did smoke, BUTS should not be able to discipline me for what I did before work even started. Also, the report they said I didn't complete was almost finished. I was waiting for my employee who was off sick with COPD to come back and insert the final vaping usage statistics. This employee is the only person who conducts the vaping surveillance. I could not submit the report without him. It's my job to make sure the report is done on time, but also that it's complete and accurate. I waited a couple of extra days to make sure all the data went into the report, but please, ALJ Geis, I know I've made some mistakes, but I've been with BUTS for 20 years. Please give me my job back.
Thank you, Appellant. Appellee's counsel, are you ready to call your first witness?
Yes. ALJ Geis, I call Virginia Slim to the stand.
Ms. Slim, will you please at this time raise your right hand for me? Ms. Slim, can you look at me, please? Thank you. Do you swear or affirm that the testimony you are about to give today will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Thank you. Ms. Pack, you may begin.
Ms. Slim, can you please identify yourself and briefly tell us who you are and about your background?
Sure. My name is Virginia Slim.
I am the director of the Ohio Bureau of Underage Tobacco Surveillance. I've served in this position for approximately 10 years. I oversee the whole bureau. Our goal is to identify tobacco usage patterns by minors, including the type and brands that they use.
Thank you. And what do you do with that information?
We use it to recommend counter-marketing efforts to dissuade teens from using specific products. It has been very effective. For example, we've seen a 65% decrease in vaping among male teens when they emphasize the adverse consequences and harms of vaping e-cigarettes by using negative imagery. And we've seen sharp reductions in menthol cigarette usage by teens by helping them understand that menthol is the same active ingredient in their grandma and grandpa's icy hot arthritis topical pain reliever.
Thank you. What is your relationship to the appellant, Winston-Salem?
I was his boss. I removed him.
I'm going to ask you to identify several exhibits now. Can you please turn to Exhibit 3 and tell me if you recognize it?
Yes, this is a pre-discipline notice that I had Nicorette Chantix type up for Mr. Salem. This document states the 2 work rules that were violated.
Now turn to Exhibit 4. Please identify it for us if you can.
Sure. This is a copy of our work rules and discipline policy. I helped draft this document back in 2010. They have not been changed since. Every employee gets a copy at hire, and then we send them out annually by email.
Okay, now turn to Exhibit 1. What is this if you know?
Sure. This is the order of removal form. I had Nicorette Chantix type it for me, and I signed it. You can see my signature right at the bottom.
And do you have the authority to remove employees for misconduct?
Yes, it states so in our enabling statute, ORC 9999.999.
Okay, why did you decide to remove the appellant Winston-Salem?
Well, first off, this is the 3rd time he violated the work rules tobacco policy. I saw a big cloud of smoke coming out from the door when he left the men's restroom. Second, he didn't submit his teenage tobacco usage report by the due date, which is very important. We use it for our counter-marketing. That's when we run ads in media to attack the popularity of certain products to make them less cool or hip. The whole reason for his job is to make sure that report is done.
You say you saw Mr. Salem come out of the restroom with a trail of smoke. Could you elaborate?
Yes, I was walking down the hall and I saw Mr. Salem, open the restroom door. There was thick cigarette smoke and it smelled horrible. I could also smell it on his clothes. I asked him what he was doing, and he scurried back to his office as if he didn't even see me. I knew he was scared that I caught him again.
Okay, and how do you know that he did not turn in the report?
Because we never received it. It comes to my desk by email. That's how it's always done. I did not get the email.
No further questions.
In the interest of administrative efficiency, I direct you to consolidate your direct examination and cross-examination for this witness, Ms. Slim. That means you will not call her back to the stand when you put on your witnesses.
Thanks, Your Honor. I don't have any questions for Ms. Slim.
Okay, Attorney Pack, do you have a next witness?
No, ALJ guys. We rest subject to rebuttal and subject to admission of our exhibits.
Mr. Salem, any objections to the admission of appellee's exhibits?
No, Your Honor. I agree that they're authentic. I just disagree with some of the facts stated in them and the result.
The documents are then admitted pursuant to a joint stipulation of the parties. Mr. Salem, do you intend to testify, and do you intend to call any witnesses?
Yes, Your Honor, I want to testify. And I also want to call one other witness.
Because you are pro se, that is representing yourself, you'll testify in the narrative form. In other words, You do not need to ask yourself questions, just please tell your story. You will, however, be subject to cross-examination. Do you understand?
Yes.
Mr. Salem, please raise your right hand for me. And do you swear or affirm that the testimony you give today will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Thank you. You may begin your testimony.
All right, Your Honor. I'd just like to say that I'm sorry the teenage tobacco usage report was not submitted on time, but it was due to things outside of my control. I needed the vaping statistics, and my employee was sick in the hospital. We are not allowed to tell each other our passwords, so I had no way to get into his computer. This is a statewide policy from the IT Security and Privacy Division. Also, Miss Slim did not see me smoking. The cloud of smoke was from our building superintendent, who was in the restroom with me. He's the son of the owner of the building. Anyway, he does whatever he wants, including smoking in the restroom. I was just trying to go to the restroom right before work started. When I came out, there was Miss Slim. I immediately went to my office so I would not be late. She has been trying to extinguish my career for a long time now. That's all I have to say about that.
Thank you. Cross-examination?
Thank you, ALJ guys. Mr. Salem, do you currently smoke?
No.
Your Honor, may I approach the witness?
Yes.
Why do I smell an odor of cigarette smoke on your clothes right now?
I object. What has that got to do with anything?
ALJ guys, I am questioning the witness' truthfulness.
I'll allow it for purposes of impeachment only. Mr. Salem, you are directed to answer the question.
Well, I've been trying to quit. I've been doing well for the last 2 weeks, but this hearing made me anxious.
So you smoked a cigarette today?
Well, yes.
So you lied to me under oath just now?
Well, not really. I quit 2 weeks ago, and I just had a few little puffs a few hours ago. That's not lying. I'm an ex-smoker. I just had a momentary relapse.
Earlier in your testimony, you stated that you could not turn in the report because statistical information was missing from one of your employees who was sick. Is that correct?
Yes.
Did you let Miss Slim know about this problem?
Well, she didn't need to hear it from me. Miss Slim knew about his absence. She must approve all absences, and she knows that his contribution is essential to the report.
Is it part of your job to communicate with your supervisor?
Well, yes, but you see, we don't get along that well. I try to avoid Miss Slim whenever I can. She was out to get me.
No further questions.
Mr. Salem, are you ready to call your next witness?
Yes, Your Honor. I call Mr. Benson N. Hedges to the stand.
Thank you. Mr. Hedges, you raise your right hand for me, please. And do you swear or affirm that the testimony you're about to give today will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Ben, do you know me?
Yes, I know you from our building.
And what is your role in the building?
I work for my dad at the building, supervising all the maintenance work.
Do you smoke?
3 packs a day.
Have you ever smoked in the restroom on the floor where Butts is located?
I hate to admit it, but I have.
Do you recall being in the restroom with me a few months ago?
Yes?
Was I smoking in the restroom?
I don't think so.
Were you smoking in the restroom?
I might have been, but I don't remember.
Nothing further, Your Honor.
Cross-examination, Attorney Pack?
Thank you, ALJ guys. Mr. Hedges, you say you remember seeing Mr. Winston in the restroom with you?
Yes.
You remember seeing him in the restroom, but you do not remember if you were smoking, and you do not remember if he was smoking.
Correct.
So it is possible that Mr. Salem was smoking in the restroom with you. Is that right?
Not that I recall.
Isn't it true that Mr. Salem would bum cigarettes from you on occasion and you would smoke together?
Well, that was way before. I don't remember that happening anytime recently.
Nothing further.
Are there any further witnesses for the appellant, Mr. Salem?
No, Your Honor.
Let's proceed to closing arguments. Mr. Salem?
Thank you. They cannot prove I smoked. Benson and Hedges was smoking in the restroom, not me. Also, Ms. Slim knew that I could not get the report done because the statistics were not available. I had to wait. I should not be fired for not doing the impossible. Please find that I did not violate the work rules and return me to my job.
Ms. Pack?
ALJ Geis, the evidence points to Mr. Salem smoking. He was in the restroom and smoking was billowing out. Mr. Hedges cannot vouch for Mr. Salem. Far from it, he is evidence that they were smoking together. That is why there was so much smoke. It does not matter that the smoking was in the restroom instead of the office at Butts. Butts banned smoking in public for the obvious reason that Butts does not want to appear hypocritical to the teens it dissuades from smoking. Finally, Mr. Salem does bear fault for not getting the report done. He supervises the completion of the report. He did not take any steps whatsoever to try to find a way to get it done. He did not even tell his boss, Ms. Slim, that there was a problem. Mr. Salem has a lot of prior discipline for similar offenses. For these reasons, we request that you recommend that the removal be affirmed.
Thank you. The Grand Board will take the matter under advisement and render the report and recommendation shortly. In fact, if you could all turn to page 10 of your books, you'll see the exhibits that were introduced through testimony at hearing during our mock hearing, which is an abbreviated amalgamation. Real hearings tend to last between 1 and 2 days on average. They usually consist of anywhere between 1 and 5 witnesses per side. So obviously we had an abbreviated hearing this morning, but on page 10, you'll see that there are some stipulations in the record, which are, I think we ALJs appreciate that. And what a stipulation is it says that the exhibits are what they purport to be. In other words, they are authentic. And so there isn't a battle in this hearing over whether the board order is the real board order, or so on and so forth. If you look at Exhibit 1, for those of you who are employed in the county or in the state of Ohio, this is a form used by the State Personnel Board of Review, published by DAS, and given to appointing authorities to effect discipline. While you don't have to use the specific form, it does have to contain all the elements of that form. And here we have a board order which says what was alleged. And the burden of proof of Ms. Pack was to show that what happened, what is said in this order is actually what happened. And that is her burden of proof by a preponderance of the evidence. That means that she has to show that what is in this order more likely than not occurred. And on Exhibit 2, you'll see that there's instructions for that order in case you ever have to issue one or in case you ever have to get one. It tells you how to appeal. On Exhibit 3, you'll see a notice of pre-discipline. And for those of you who do any HR, you probably have heard of the case of Loudermill versus Cleveland, that before taking an action against an employee, an appointing authority, that is a public employer, has to tell the employee that they're contemplating discipline against them and give them an opportunity to provide information before they carry out that adverse action. On Exhibit 4, you'll see the work rules and discipline policy of the appointing authority, Butts. As you can see, it's a little abbreviated and much shorter than real workplace discipline policies that we find around the state and the counties. And then if you go to Exhibit 5, we start to see prior discipline. We do have a rule in the Ohio Administrative Code where our board is allowed to consider prior discipline for purposes of showing that the employee was warned or noticed about certain misconduct, or if there's a particular pattern that is relevant to the case. Well, board, the last exhibit, Exhibit 7, is something we also often see in joint exhibits or exhibits of the appellee, The appellee is the appointing authority, and they, again, have the burden in a regular discipline case to show what they put in their order is true, and then also that the adverse action in the order, whether it be a suspension or a removal, is an appropriate discipline under the circumstances. On page 18, you'll see a few questions that maybe you'll want to ask yourself as a board when you go to consider, but I'd like you to now turn to page 19. What I do after I conduct hearings is I write a report and recommendation, and that report and recommendation contains finding of facts. In other words, what happened? Did the tree fall or did the tree not fall? Did the declarant say, I'm going to get you, or did he say something else or nothing at all? Those are findings of fact, and they're heavily dependent on the testimony and the documentary evidence. And you'll see there on your report and recommendation that you're going to write, and by the way, at your tables, you only need to have one person write it out. You're welcome to take notes. But we will be going around and seeing, what do you as jurors, as fact finders, think in terms of what was proven in this case, and also what you think about what an appropriate discipline would be, either none or something else, depending on your findings. A couple of things before you begin. The standard of review for anything I write and send to my board of 3 persons who makes a final order and either accepts my recommendation or modifies it, the standard of review in the Court of Common Pleas is that the board must make its decisions on evidence that is reliable, probative, and substantial. And that is the standard. And that simply means, in layperson terms, that the evidence has to be reliable. It has to tend to move the meter in the sense that it shows what happened. Irrelevant evidence is, the house is blue. It comes in during the case and we find out that the appellant lives in a blue house. But the blue house has nothing to do with his smoking or not smoking. So that evidence wouldn't be probative. And then the evidence has to be substantial, which means that the evidence that's included has to have some weight to it. It's something that has an effect on the hearer that says, ooh, I know what that means. And then finally, I'll just tell you the basic difference between direct and circumstantial evidence. On cop shows, it seems like circumstantial is a bad word. In fact, circumstantial evidence is some of the most reliable and probative evidence there is. Direct evidence is evidence that you hear at hearing through testimony or that comes through an authenticated document. So a fake birth certificate can be direct evidence, but it can still be fake, in which case it wouldn't be very reliable. And the same thing goes with testimony. If I say I wasn't there on November 22nd, that's direct testimony. But if you can produce a video of me walking around the place on that date, you could infer, you could make an educated guess that I was actually there, and that, my friends, is what circumstantial evidence is. It requires an inference. So I hope you were listening carefully to the skit today because it is an abbreviated hearing. Again, we did it in 20 minutes instead of the typical 5 to 7 hours or 14 hours that it takes. But I think you can draw the point from it, and it will help you in your HR function as you go and be thinking like a person who is a fact finder so that you can, when you do your administrative investigations, you can notice certain things that are important and you can kind of start to plan ahead for how you would present that information on appeal. So in your tables, I would like you to discuss your findings of fact. And you need to either be unanimous or have a majority of you in order to make that finding. So while you might individually disagree, in this case, in my own real life job, I have to convince at least 3 people that my findings of fact are correct. They may not always agree, and they don't have to. And that's why I try to marshal that evidence and put it in a report. So the first thing you're going to do is decide, did he smoke or not in the bathroom? And we have some conflicting evidence here. So you want to discuss that in your groups. You need to elect a presiding chairperson so that person can write down the finding for the final order. And you'll see the findings of fact contains 2 questions. But once you find your facts, you also have to draw conclusions of law. The operative statute for most of what we do at SPBR, except for our special jurisdictions on whistleblowing and OSHA, which I will get to later in the day, is RC 124.34. And what that statute basically says is that employees are entitled to their positions, except for during times of economic layoff, during good and efficient service. So that means when they're not good, they fail in good behavior, or they're inefficient, or they're incompetent, or drunken publicly, or other things. It's a long statute. They may not be entitled to serve in that position any longer. So the degree of discipline that a person can receive is anything from a written reprimand all the way up to termination, which we call removal. And so as a board, you need to decide what the appropriate discipline is, if any, assuming that your findings of fact reflect that there is something wrong or not. Okay. I'll be around, walking around, to see if you have questions, but you can go ahead and start your discussion. All right, everyone. I hope you had a good time trying to develop a consensus. By the way, if you want to do this in real life like Mr. Casey does, you have to get an appointment from the governor. So not everybody will get to actually be a real board member in their lifetime. But in any event, we do want you to understand what goes into a case and how the board makes its decisions and how it relies on its administrative law judges to make findings of fact and draw conclusions to recommend to them. And so I want to do just a show of hands first before we talk with some of the boards, so to speak, board spokesperson. How many of you found, raise your hand if you found that it is more likely than not that Winston-Salem smoked in the bathroom? Okay. So we have roughly about 45% of the crowd. Okay. Now, let me see you if you voted that there was not substantial evidence that he smoked in the bathroom. Okay. So again, we have a divide here, and that's probably by no mistake. And sometimes the cases are that way. But I can't just say, I don't know. They pay me to say it happened or it didn't happen. I have to follow that more likely than not standard. Okay? So it's not beyond a reasonable doubt, like it is in criminal law. It's preponderance. It's more likely than not. Okay, what about number 2, the performance-based issue? Did Winston-Salem perform his job duties? One of the things I go through and do when I analyze a case is I figure out where the testimony aligns. I figure out where the supporting documents support the testimony or the documentary evidence. So I want to find out what is in agreement before I figure out what the answer is to facts in dispute. Let's take a look and see how many of you voted that Winston had some fault for the report not being completed. Raise your hands. Okay. So again, it's about roughly half the room. How many of you decided that there was not enough evidence to show that Winston had a non-delegable duty? In other words, part of his duty remained his, was not his subordinates, and he should have, let me flip it, let me reverse it. How many of you decided that there just wasn't enough evidence that he was responsible for messing up the report? So a lot less then. So most of you, let me just see that again. How many of you felt the supervisor should bear some fault, some responsibility for that report not getting done on time? Raise your hands. Okay, interesting. Okay, interesting. So we have a lot more of you. So it looks like most of you found that the supervisor was at fault for at least count 2, if not count 1, too. Let's talk about conclusions. The conclusions follow the facts, right? So if you determine that he smoked in the bathroom, you would most likely find that he violated Butt's rules if he were on the premises. But since he's not on the premises, there's this other analysis you have to do that is, was he working? Was it before work? Was it after work? Because, as civil servants, we don't give up our liberty interest at the door, right? So to a certain extent, you're allowed to say things and do things outside of work. There are some exceptions, of course. You do give up a few of your rights, depending on where you work. If you're in a correction setting, for example, there's this thing called spirit de corps or discipline, paramilitary discipline. And so sometimes you're not as free to say things on the outside as you would be if you were just a general office worker. But that's for another day. The question is it connected enough? Is that conduct connected enough to the mission of the agency, to the import of the agency, that you would still find him guilty of an R12434 offense, even if it's not on their property? Okay, so let's see what you thought. How many of you concluded that Mr. Winston-Salem violated the rules regarding smoking? Raise your hands. Okay, substantial minority of you, but certainly not a majority. How many of you felt that Winston-Salem did not violate the smoking rules? So we have a few more of you with your hands up. A lot of people kind of didn't vote. So how many of you determined that technically it wasn't a violation because he was off Buck's property? Raise your hand. Okay, so a couple people did. And then how many of you found that there was a nexus, that is a sufficient connection between his conduct and the agency mission that you counted it as a violation? Okay, a couple people. Okay, these are the things that we have to think through. Okay, and we're not about hyper-technicalities. We know that there's nexus connections between people where they do things. Like, for example, if you're on the clock and you go down the road, down Broad Street at 100 miles an hour and hit someone and kill them, you know, what's your employment going to look like with a state employer? Probably not real good if you were on the clock. Yeah, so there is those things, connection, even though you're not physically at the facility. So let's go to the last conclusion, and that would be on number 2. Winston-Salem, did he violate the rules regarding work completion? How many of you say yes, yes he did? Okay, and how many of you say no? Okay, I got a few of you. Okay, so let's do our last voting, and then I want to hear some explanations from some of you. Number 1, and I want to hear just from spokespersons of group, because I asked you to have a spokesperson, so I only need to hear one person per table. Okay, but we're just going to still do a show of hands. You're supposed to elect a chairman. You're supposed to. If you haven't, elect a chairperson right now to speak for the majority of your board. When I say affirm an order, what that means is if you vote to affirm, that means you're going to uphold the appointing authority's order to remove Winston-Salem. Okay? Okay, spokespeople, I should see at least one hand from each table after these 2 questions. How many of you voted to affirm? That means just as they put it, affirm the removal. How many of you voted to affirm? Anybody? Okay, so we have one table that affirmed. Okay, just one. Okay. How many of you, now here's where it gets a little tricky. Disaffirming in whole means that Winston gets no discipline whatsoever. He gets returned to his job and he gets full back pay. Okay? Disaffirming. Then there's what we call modification. Modification, some of the lawyers that appear before me who argue in their post-hearing briefs against Solomonic law of splitting the baby, which means that there's a modification. So you might not have upheld the removal, but you upheld some level of discipline basing on the charges you sustained. So first let me hear from any table completely disaffirm the order and send Winston-Salem back to his job, happily smoking along the way. Nobody did. Nobody did. Okay. How about let's talk about modification now. How many modified, which meant that you reduced the removal to something else? Okay. Now I need to hear from some spokespeople. So spokespeople, keep your hands up. Keep your hands up. Okay. And Justin, can you come over here? You come over here this way. See this gentleman with the very fine head of hair? Okay? Let's hear from this chairman of the board. What did you do and why?
So we modified it to a 4-day suspension.
4 days.
Yes.
And what was your basis for that?
There were some mitigating factors, and also looking at their disciplinary policy, it shows that progressive discipline should be implemented when appropriate. Didn't feel that we found both, there was a violation regarding work completion as well as smoking on premises, but we felt that it wasn't egregious enough to go to full removal. There were other mitigating factors as well, such as the password access, and also that there was a failure to supervise from Virginia Slim she should have communicated with as well.
Okay, now let me ask you, did you find him guilty of all charges or just one?
All.
Okay, you did.
Yes.
So you incorporated that. Okay, interesting. So let me ask you, was your table unanimous? Was there some negotiation to get to the 4 days, or?
I think we were unanimous, right? Yeah.
Okay, and you pulled 4. Did you? Let me ask you the rhetorical question. I assume you didn't pull it out of the hat. So how did you get to 4? What made you decide?
I think we all kind of looked at each other and said, if we would have affirmed, it didn't feel right. And this affirmation just didn't feel right either. The whole Solomonic splitting the baby seemed to be more appropriate, just given the testimony. Again, it kind of seemed like there were some red herrings from his buddy who he bumped cigs off of, but more or less what he was accused of and what we found more likely than not to have occurred did not warrant a full removal from his position. And again, the mitigating factors seemed to indicate that a medium suspension of 2 to 4 days was more appropriate.
Okay, so you answered my next question was, you did go back and you looked at the employer's policy. Now, I want you to know for SPBR cases, we are not bound like arbitrators are to apply the contract, because there is no contract with classified exempt employees. And the board they have a lot of discretion to decide what the most appropriate discipline is. I do look to employer discipline policies. I at least always look at them. And I do sometimes choose to defer to them if I know that the middle level of discipline is indicated. Some places it's 2 to 5 days, some places it's 1 day, other places it's 30 days. Sometimes I will do that. Some of my colleagues look more to what we call traditional board jurisprudence. The board, I think, I don't want to misspeak, but the board has sometimes handed out 30-day suspensions, sometimes 60-day and sometimes 90. And they can choose to do that even though I might recommend following the employer's grid. They might say, well, we don't think that's appropriate in this case. We want to go with board jurisprudence instead of deferring to the employer. However, those discipline policies are still important. We consider aggravating and mitigating factors. We don't, strictly speaking, apply progressive discipline. We do look at, last question for you, did the other disciplines that this man had, did they play any role into your adjusting it to a 4?
I think so, because that would be in line with the progressive discipline. And again, I think we didn't explicitly discuss it, but I think it felt like that we looked at the level of violations before. What is the intensity of the violation, of the last 2 write-ups? Okay, write-up, 1-day suspension. Would this warrant a progressive discipline? Okay. Or is this egregious conduct that we throw progressive discipline?
So you didn't go backwards, in other words? No. Right. Okay. Thank you so much for speaking. I need another spokesperson volunteer. I see a gentleman there in his very colorful shirt. I have one just like that at home. Great color. All right, so let me ask you, what did you come up with and why?
Well, it's quite different. That's why I was anxious to go ahead and go next. First of all, I think the consensus was for us that the company didn't do a very good job of proving that he smoked. Possible, of course, but they didn't prove it. And honestly, I would have separated those 2 things instead of handling them together. If it was a real life situation. So as far as the smoking, we didn't find anything because there was nothing proven. Yes, he admitted to smoking earlier, but we have no idea where that was at. It may not have been public. Well, it could have been anywhere when he said he smoked earlier that day, a couple puffs. So as far as that goes, that was pretty much thrown out because it wasn't proven.
Okay.
But as far as the other part about not completing the work, We went back and looked at the prior discipline, it's over 2 years. So we disregard that and throw that out because you can't use that towards progressive discipline. So this would be like a first offense all over again.
All right, well, two things. I don't want to forget them because they're very important. Number one, the official rule, and you wouldn't know this, the DAS rule for state employees is they'll hold on to those disciplines for 3 years and then they expire. Counties can be different. And I've seen some where they go 2, some where they go 1 for their exempt employees. But based on the facts, your analysis is good, which is, well, this discipline's too old for us, or it's old enough that we're not going to give it the same weight we would if it just happened yesterday. Right. The second very important thing that you brought up, and this is why I love going around and getting ideas from the audience, we do have a rule called merger and bar, which means that if you know about 2 incidents that were committed by your employee, and one happened earlier in time and one happened later in time, you have to put those together and merge them into a single discipline, because if you just go with the latter offense, you're going to lose the ability to deal with this earlier offense. And the reason we have that rule is because we know, I don't know if we actually knew, but institutionally, I used to work as a labor relations manager. Before that, I was a union president, so I did a lot of arbitration type work. And one thing employers love to do is stack charges, where they would basically just like save up, and they say, oh, we did 5 things, let's go for summary discharge. And, the union would say, well, wait a minute, you know about this stuff. Why didn't you give a chance to correct their behavior? Why didn't you, if this is important 2 years later, why wasn't it important back then? So our merger and bar rule is that, number one, if it's older than 2 years and you knew about it, you're not bringing it up. That's our statute of repose or statute of limitations. So you do need to act relatively quickly, but 2 years is a long time versus other forms. The second thing is, if you are going to put 2 different rule violations or 2 different misconducts together, you have to. You got to put it together. You can't just wait and go after the former after you've done with the latter. Was there anything else that you wanted to comment to? All right. Well, I appreciate that. We have time for one more, and I'd just like to I see a volunteer over here, a volunteer spokesperson. This nice lady with, she has Justin she's right over here, right up in front, or Lakesha, I'm sorry. Yeah, we're trying to get somebody over to you so you don't have to yell. So, Lakesha, if you could hand.
Thank you. I don't have the voice, so I definitely need a mic.
So what did you decide and why?
So there's a few things that we didn't like, and I'll preempt it with, I think the important thing that at least we take from it is that we might be the judge when it comes to whether we're going to put forth that 40-55, but the final judge is the people that view that. So if it's a weak case and it goes against us, we got a whole lot of making up to do, and that's not going to go well. So I always tell my offices, if it doesn't look good on paper, it's not going to look good to the next person that has to read through that. So we always have to keep in mind that we're not that final judge. And when you look through this, the very first offense was Miss Slim, who said he spit chewing tobacco in the urinal. Well, unless she was in the men's restroom, that's pretty weak. And so I think that's something that was that should have just been a verbal, hey, somebody saw this and that's against it. I didn't see it, but that should have just been the verbal.
What was she doing in the men's bathroom anyhow?
Exactly.
Well, that's a whole new controversy today, right? Yeah.
Exactly. Yeah.
We got to look at her pronouns, right?
Pardon me?
We got to look at her pronouns. We got to put that in for next year. All right, go ahead.
So then the second offense would have been that written warning, and then the third offense, which they put on a 40-55, should have really been a suspension. And my personal opinion is I would have did a 3-day, not a 4, just because it's not appealable.
Okay.
So I would have done that.
Ooh,
so that then,
you know what? That brings up another good point. Wow, you've been around the block a little bit, huh?
So yeah, and then we had another good comment about offering him cessation counseling, because obviously smoking's hard to kick. So just throwing out a discipline is going to be hard for somebody who has
excellent points, and I want to bring them up and capture them. So number one, our HR person who I know she has an HR background, she knows that the board cannot consider suspensions for overtime employees unless they're in excess of 3 days. And if they are for overtime exempt employees, we don't have jurisdiction until you hit the 6-day mark for the suspension. So that's a very important point. Yeah, if you have kind of a weak case, but you want to send a point, you know, I won't be touching the case unless it's over 3 days for overtime eligible and 5 days for overtime exempt. And I think you're right. Employers have to make trade-offs, because since you do have a burden of proof, if a case is weak and you go after removal, you know that you know, you might get that person back. On the other hand, depending on the type of offense, you know, consider this, for example. Let's say you have someone that you think is guilty of sexual harassment, or someone that is involved in a bad fight, but the witnesses just aren't there to support who was at fault. I mean, what do? Employers have to make decisions. Well, do I discipline both? Do I fire both? Or if it's something like a drug abuse, you know, in the first instance, do I offer them rehabilitation? Maybe not discipline them, or maybe I send them to EAP or employee assistance program, have them sign a contract or something like that before we leave to go to lunch. And we're going to do that in just 1 second. I know one group did say, well, we were going to offer them a last chance agreement and include a 5-day suspension with it. If you look at 124.34, there is a provision in there that allows you to negotiate with your exempt employee's attorney, or with them if they are unrepresented, and come to an agreement for a last chance. And what that does is it deprives the board of modification jurisdiction if that person violates their last chance agreement. So the only thing that I would consider in that case was the LCA, last chance agreement, was that violated or not? And I could not recommend to modify the penalty. Okay? You have been a wonderful audience. It's lunchtime, and it's right across from you, so we'll see you this afternoon after lunch. Thank you.